Hi, my name is Kathleen Halley, and I'm a digital forensics major here at Bloomsburg University. And today I will be talking to you about selective seizures of digital evidence. What is it, you may be wondering? It's a highly specific taking possession of digital property by a legal process. So digital evidence specifically is the information stored or transmitted on a digital device in binary form that may be relied upon in court. So there are different kinds of data, and three main types of data that we do talk about are volatile data, stored data, and manipulated data. Volatile data is the kind of data that kind of resets or clears when a device is turned off or powered back on. So that would be your RAM, your cache, and your network status. Then you have stored data, which can be fragile, hidden, or temporary. These are things such as regular old files, your pictures that you have stored, anything that's just regularly stored on your directory. Then you have manipulated data, which can be encrypted or use stenography to make it harder to access, such as an embedded file inside of a JPEG could be manipulated data. All of these types of data are stored in various locations of the hard drive, which means that you could have one picture, but it be stored in different sections on the hard drive. A little background about selective seizure and digital information involving court cases is that in the past 10 years, digital information and digital evidence has been used more frequently in court cases in order to bring about a conviction. This kind of evidence includes text messages from a cell phone, deleted files on a hard drive, pictures on a cell phone, or on just a regular DSL camera. Another thing that we need to know about is what are the rules of evidence. So there's 5 quick rules, which that the evidence must be admissible, authentic, complete, reliable, and believable. Meaning admissible, meaning that you can and it is collected in a way in which you can use it in court. Authentic as in it is the real deal, exactly what was found is what is being shown. Complete is that not only is some of the data being shown, but all of it's being shown so that it doesn't skew the jury to one or the other. Reliable, as in the person collecting it is reliable, and we know that they're not going to mess with the data in any sort of way. And then believable is that we're not saying that someone did something that they're totally not even being accused of, or something in that realm. A key court case when talking about selective seizures as digital evidence is the case of the United States versus Ganius. This brings to light the evident lack of interpretation of the Constitution to technology currently in the 21st century. The case was based upon an appeal from a conviction of Stavros M. Ganius for tax evasion following a jury trial. The appeal was presented on the basis that his Fourth Amendment rights were violated by the government. The government, when they looked into his tax evasion, copied 3 computer hard drives with a search warrant, but they retained the files beyond the time constraints of the warrant. This is where he argued that his Fourth Amendment rights were violated based on the prohibition of unreasonable seizures. The Second Circuit panel then heard the case, which led to his conviction being overturned. The court did not rule on whether the retention of forensic mirrors, aka copies of digital hard drives, violated the Fourth Amendment. So forensically speaking, we do say it's required that a complete mirror image of the hard drive is made, but yet the general public sees this as a potentially invasive tactic. Yet an investigator is unable to conclusively know if all files have been detected, hidden, or deleted from the entirety of the device without being able to see the whole hard drive. If someone is trying to hide something, it may be in an unsuspecting location, such as a spyware file being hidden inside of a JPEG image. This would not be accessible if you only had a partial copy of the drive. Some say that judges should think about issuing warrants for all digital data, but if they only issued warrants for certain files, they may be missing key aspects of the cases and therefore leaving criminals on the loose. So we do talk about how digital is different. This means that digital evidence isn't really the same as physical evidence in a court case and should be treated differently. With physical evidence, if there's an absence of information, it is unlikely to be recovered, whereas with digital evidence, the absence of data can sometimes be the key to solving a case. Furthermore, with physical files, it is only required to seize the singular file, or even if it's not a file, if it's like a fingerprint or a bloodstain, you only need that one singular thing. But with digital evidence, a singular file can be embedded with many different sections of the metadata. In order to know you're getting all of the digital file, it's crucial to have a complete copy of the hard drive. So when you store a file on your computer, it's saved in numerous locations. So if you only have the one location of it, it may be different in other locations. So what do you think? Is it crucial to have complete images of hard drives, or should only a few files be sufficient in order to see if someone has broken the law or has, in this case, dealt with tax evasion or in some cases child pornography? It's really up to us now to decide. Thank you so much for listening.